Hello, everyone. Welcome to the 2020 Hot Topics in Environmental Law lecture series brought to you by the Environmental Law Center. I'm Jenny Rushlow, and I'm Director of the Environmental Law Center and Associate Dean for Environmental Programs at Vermont Law School. I'm going to bring up a list of resources on the screen to direct you to some of the programs that we have at the Environmental Law Center for those of you who are looking to learn more. And you can also view our full Hot Topics lineup by going to our website, vermontlaw.edu/hot-topics. For those of you who are attorneys looking to get continuing legal education credit, each talk is worth 1 Vermont CLE credit, so please keep track of which talks you attend for your records. We'll have time for questions and answers after today's presentation, so please do type your questions into the chat box. You can do that at any time during the lecture, and we'll get to as many as we can in the remaining time. Today, we are very pleased to welcome Dr. Geoffrey Garver. Dr. Garver teaches environmental courses at McGill University and Concordia University in Montreal and coordinates law and governance research for the leadership for the Ecozoic program, formerly the Economics for the Anthropocene Partnership. He's on the steering committee of the Ecological Law and Governance Association and is active in the international degrowth movement. From 2000 to 2007, he was Director of Submission on Enforcement Matters at the Commission for Environmental Cooperation, and that followed 13 years of public service with the U.S. Department of Justice, the U.S. Environmental Protection Agency, and a federal district court judge in Maine. Dr. Garver co-authored Right Relationship, Building a Whole Earth Economy, and many articles and book chapters. His book, Ecological Law and the Planetary Crisis, is coming out in October 2020. Dr. Garver completed his PhD at McGill, a bachelor's from Cornell University, a JD from Michigan Law School, and an LLM from McGill. Today, his talk is titled Ecological Law, a Transformational Approach for Legal Systems. Welcome, Dr. Garver. Take it away.
Well, thank you so much, Jenny. And I also want to extend thanks to Courtney Collins and Emily Potts for the invitation and for helping me get ready for the technical side of this and a little run through. And I just want to start by saying I am so appreciative of this opportunity. Vermont Law School is a leader and has been for a long time in environmental law. And in the new ideas that are emerging related to like the one that I'll be talking to you about today. So I'm going to start my PowerPoint now. Yeah, so my topic today is ecological law, a transformational approach for legal systems. And what I'm going to, I came to this topic after a long career in the U.S. government and the Commission for Environmental Cooperation, working with the environmental laws that arose from the environmental awakening of the 1960s and 70s. NEPA, all of the media statutes, and especially the land and resource management laws in the United States. So I appreciate very much those environmental laws and the environmental gains they've allowed. But my talk today is about the fact that it's time. In fact, it's urgent to move forward with a new framing of our environmental and ecological challenges and how to respond to them. So what I'm going to do in this talk is first give a broad overview of ecological law, why we need it, what it is, and how it differs from environmental law. And then I'll spend a little more time on the details of the problems that ecological law is responding to, the kinds of solutions it offers, and how we get there. Now, I'm probably going to raise more questions than I'm going to provide answers. So I'll try to wrap up in plenty of time to get at least some of those questions on the table. So I want to start here by just providing a perspective of where we are as a society, as a global society. And I think these two graphs, which I discovered when I was first entering into my graduate studies, really tell this picture very well. And so what you have here on one side, on the left side, are the socioeconomic trends that have brought us to where we are today. And we're talking about the period 1750 to the present, roughly from the beginning of the Industrial Revolution to today. So you can see here you have population, GDP growth, and then a number of other things related to an industrial society: fertilizer consumption, paper, water use, and so on. And on the other side, Earth system trends, we can see the ecological ramifications of this: rising carbon dioxide, and loss of biodiversity, and so on. So this is really just shows you the correlation. The next slide I have for you on the planetary boundaries, and I hope many of you are familiar with this. I've given you a citation below if you want to learn more. The planetary boundaries work is really a new framing of the ecological challenges that we face today, and that have given rise to this correlation in economic activity and rising ecological problems. So what this graph tells us, in addition to those that correlation, is that we've also started to cross some very critical thresholds. And you can see in this graph, it's showing in the red zones that we've already started to cross thresholds in regard to biosphere integrity, in particular, the extinctions per million species per year, and in the loading of phosphorus and nitrogen into our ecosystems. The yellow zone means we're in an unsafe or a dangerous zone of uncertainty for other planetary boundaries, such as climate change, land and land system change. The green zones, according to this research, says, well, we're maybe okay for now, but as you can see from those graphs and the strong correlation between economic activity and environmental challenges, we may not remain there for a long time. And what's different about this framing is that it looks at much more holistically at the kinds of environmental problems and issues that have, in many senses, fallen through the cracks of our current environmental law system. So if you put these two graphs together, what it amounts to is a clash of two mutually exclusive narratives. And on one side, you have a growth-insistent narrative. This is the dominant narrative of our economics and the legal systems that support it. This is the narrative of virtually every country playing on the world stage today, of the G20 group of governments, of the United Nations and its definition of sustainable development, its sustainable development goals, and so on. And really of any economist who has a solid position in a typical economics department in any university in the world. The neoclassical economists, the economists that our policymakers and decision makers tend to listen to. And that growth-insistent paradigm and narrative is in a clash with a limits-insistent narrative and paradigm. This is the world of ecological economists and the work of some of its leaders, such as Kenneth Boulding, who gave us the idea of the Earth as a spaceship, just to underscore how finite it is. Herman Daly, who's been a true leader. There's many more other names I could have listed there. But this is a paradigm in which a primary focus on limits is essential. So these two narratives are in dynamic tension more and more, as that first graph I showed you is making clear. And in this dynamic tension is created space for the development of new ideas for responding to our ecological challenges and the related social challenges. So this is where the idea that Thomas Berry gave us of a mutually enhancing human-Earth relationship has space to develop and gain more meaning and room in our policy world. It's a space in which the primacy of ecological limits and the need for that is becoming clearer. It's a space for developing better systems for interhuman, interspecies, and intergenerational fairness. This is the world in which ecological economics and the degrowth movement is evolving. And it's the space in which ecological governance is also starting to emerge. So what is ecological law? Well, keeping with an overview, I'm going to just throw a lot of these features at you, and then as I go along, hopefully some of them will become more clear. So it's a view of law or in jurisprudence in which humans are seen as part of Earth's life systems, not separate from them. It's a world in which there's primacy for ecological boundaries over socioeconomic spheres. Ecological law insists on full integration of ecological limits and rules and policy, which distinguishes it from environmental law in that it's not a boutique side area of the law. It's an area of the law that really has to integrate every corner of our legal system. Given the kind of information I showed you on planetary boundaries and rising ecological impacts of socioeconomic activity, we need immediately to focus on reducing the material and energy throughput that causes those ecological problems. Use of biocapacity and extracted materials needs to be based on real need more than on utilitarian desires. So ecological law includes a move away from market prices towards other ways of making societal decisions. Another feature is that it creates a plurality of diverse place-based approaches, but is global in scope because many of these problems are global. And this is really another way of stating the rule of subsidiarity, which I'll mention again a little bit later. It has implications in our current system of the need for binding supranational rules. So it's a challenge in many ways to the sovereignty of states in areas where there's been a lot of resistance up until now. Again, fair sharing among present and future generations of life. And it also implies a greatly expanded research and monitoring system where we're researching and monitoring different kinds of things really related to whether we're complying with planetary boundaries and other limits, and if not, what we need to do. It incorporates precaution about crossing boundaries. So those yellow zones I showed you on the planetary boundaries slide demonstrate that. The transition from the green zone where we're safe to the yellow zone where we don't really know. Precaution says we really should stop at the edge of the green zone. And then finally, and this is a real challenge for law, as you can imagine, ecological law needs to be adapted. It needs to have a systems-based approach to receive this information and respond to it. A lot of those features have been digested just brilliantly, in my view, by Carla Spaert in a new book that she's written called The Lens of Ecological Law. So she focuses on three primary features: ecocentrism, ecological primacy, and ecological justice. These three features really just categorize and sort out a little some of the features that I mentioned in the previous slide. I highly commend her book, which has just come out in April of this year, to get a better flavor of her perspective. So how does ecological law compare to environmental law on various issues? And you'll see here that I'm emphasizing contemporary law as opposed to environmental law. And this is really to drive home the point that when we talk about ecological law, we're not talking only about replacing or an alternative to environmental law, but really to all corners of contemporary law. So you can see it differs on the human-nature relationship. Instead of seeing humans separate from and superior to nature, ecological law sees humans as part of nature and aims to foster a mutually enhancing human-earth relationship. There are differences in how enforceable eco-limits are, which enforceable eco-limits are recognized and enforced. In contemporary law, many of those limits are reductionist, they're end of pipe, they're fragmented, they don't look at a holistic picture, and they're subordinate to economic growth and property rights. Whereas in ecological law, there's a much more holistic approach. In terms of use of materials and energy, it's a real distinction between efficiency, which much of our contemporary law and economics promotes, a shift towards sufficiency and really meeting basic needs, and then starting to sort of move away from various luxuries and things that aren't truly needed. In terms of scale, well, the distinction I make here is that our contemporary legal systems are really strongly committed to state sovereignty, whereas ecological law would really look beyond those boundaries and look at more ecosystems-based approaches. In terms of fairness, in our current system of law, legal systems, we have a core belief in fairness of markets, with some corrections like polluter pays, externalities, and so on, and a tendency to monetize environmental harms. And under ecological law, there would be stronger limits on market mechanisms and a bigger role for non-market decision-making, and a focus on interhuman, interspecies, and intergenerational fairness that doesn't use money as a metric, or as a key metric. Last, on research, monitoring, and adaptation. In our current system, the effects on human health are paramount. Environmental effects are studied, but they're not determinative, and there's really a weak precautionary approach. We can see this especially in the United States, where things are allowed unless they're proven to be dangerous, where a precautionary approach would turn that around. So an ecological law, planetary boundaries, safe operating space, and a precautionary approach would be much more front and center. So now, with that overview, I'm going to go into a little more detail for what it would entail to shift from a contemporary law to ecological law. And I'm breaking this down into what the problem is, why do we need to move from contemporary to ecological law, the solution, what does ecological law mean, and third, the challenge of transition from contemporary to ecological law. And before I get into those details, I just want to ask you all to keep in mind that you need to keep in your focus here all of the relevant features of legal systems that this shift would entail. So we have to consider the context in which legal systems exist. So there's always, from a systems perspective, a link between our legal systems and our ecological systems, our social systems, our political, cultural, and economic systems. So when we talk about transforming towards ecological law, we're really talking also about transforming those other systems in some way as well. And tied to that is that there's always an underlying worldview or ethical point of view under a legal system. So this approach really requires taking a deep look at that, and where necessary, focusing on shifting some of those worldviews. For example, in my opening or my third slide, about these mutually clashing narratives. Those are deep-seated features of our current system, ones that will take a long time to overcome. We also have to keep in mind forms of law, and really what I'll say here is that I take in my work a pluralistic view of the law. So this allows us to look at customary ways in which societies have found ways to regulate behavior that don't always follow what we typically think of as law when we go to law school, and so on. So we can find this in a religious system where shaming or stigma will really keep people from doing certain things. And I think this broader view of law is necessary when we think of ecological law. Also can keep in mind all the different actors, agents, institutions, and power structures involved: lawmakers, law abiders, judges, legislators, ordinary citizens, and so on. And then we have these many different arenas in which we think of law. There are rights-based arenas or rights-based approaches: rights for humans, rights for juridical persons such as corporations and non-human nature. We have economic spheres, financial and monetary systems, contracts, commerce, trade. All of those fields are relevant to this shift towards ecological law. Our law and legal systems sorting out our understanding of property regimes, private property, public property, and the commons are also relevant. And then we have sectoral dimensions in which you can look at this: energy, food, water, transportation, and so on. So the problem, well, I'll start with one of my favorite of all time New Yorker cartoons that really frames the big problem. And Mankoff really hits the nail on the head often, if you ask me. So while the end of the world scenario will be rife with unimaginable horrors, we believe that the pre-end period will be filled with unprecedented opportunities for profit. You know, unfortunately, that really sums up a lot of the problem that we're trying to deal with here. In terms of environmental law, I like this quote from the Oslo Manifesto for Ecological Law and Governance, and I'll show you how to see that in full in a minute. It was the declaration that really gave birth to the most rigorous current effort to develop ecological law internationally. And it gave birth also to the Ecological Law and Governance Association. But what this manifesto says is that a part of the problem is that environmental law is rooted in modern Western law with its origins in religious anthropocentrism, Cartesian dualism, philosophical individualism, and ethical utilitarianism. So the implications of that I'll try to explain as I go through these examples. Now, when I started to think about ecological law, I really dug in when I did my law master's at McGill. And the question I started out with was, well, I had discovered the world of ecological economics. And so I was asking myself, what is the equivalent to law of ecological economics? To economics, and I came up with the phrase, the rule of ecological law. And what I tried to see there was whether in the existing environmental regimes that I am familiar with, which of them seem to have a systems-based or ecosystems-based core, or at least objective, and how are they doing at giving that primacy? And so I looked at these examples: the Montreal Protocol on ozone depleting substances, the U.S. Clean Air Act provisions on climate change, the international agreements on climate change, various aspects of the U.S. Clean Water Act dealing with total maximum daily loads and acid rain, and then the mostly Europe-based Convention on Long-Range Transboundary Air Pollution. So what I found is that with the Montreal Protocol, we've had modest success. And if you noticed on the planetary boundary slide, this is actually one of the planetary boundaries. It's global in scope, and we have identified some critical thresholds. And because of the Montreal Protocol, which was adopted in 1987, and the various amendments to it, we seem to be on track to address the bulk of this problem. For all the others, I gave a failing grade because they essentially didn't have strong regimes for protecting the ecosystems that they were designed to protect. And when you sorted them out, when you went through the details and the fine print, it became clear that all of those limits were subject to economic and technological concerns. Why do we have this problem? Well, again, what I drew out of here is at the heart of the problem with environmental law were these core foundations of the dominant regime that law currently serves. First, again, this strong commitment to infinite economic growth on a finite planet. Second, state sovereignty is a strong barrier to strong international rules for the environment, even though other provisions of international law make clear that if countries want to be serious about supranational requirements, they know how to do it. And you can only have to look at the investors' rights under many trade laws and compare those to, say, climate change commitments. One quite mandatory, the other's much softer. Another set of barriers have to do with privatization and strong protection of private property rights, increasing use of monetization and commodification, for example, by valuation of ecosystem services, and then capitalism and protection of corporations as providing the kind of security that we need to keep people employed and happy and so on. Well, each of these is a strong topic in itself, but in an overview presentation, let me just focus on one of them. And this is with privatization and private property. So I've looked at this problem of remote ownership. And what I'm talking about here, in many senses, is land and resource grabbing. So we see this really all over the world. In a typical case, say in Africa, you have many African countries that offer long-term land leases to companies outside of the country or other countries that don't have enough room, say for agriculture, to lease the land. And with that, they are guaranteed efforts to move the people and any wildlife using that land off the land, essentially permanently. So you can see this, number one, as a modern legacy of colonialism. And my argument on that is that the legitimacy of much of this colonial legacy is unquestioned by the vast majority. A recent column by George Mambia talked about how we airbrush history to get rid of some of the uglier parts of this legacy. So these are a lot of these land and resource grab deals are cast as providing for people, they're promised schools or hospitals that never materialize in exchange for giving up their land and their long-standing relationship with that land. So remote ownership, for example, investment opportunities in land-grabbing corporations, almost invariably ignores local concerns. What people are concerned when they invest, say, in an agricultural endeavor in Africa is they want to know what the return is going to be. And that's it. Is this going to make me money or not? And yet that decision, each shareholder that makes that an investment opportunity is having an impact on the people and the land that are affected. Modern trade and investment agreements typically have strong protections for this kind of land and resource grabbing. NAFTA, now transitioning to the U.S. Mexico Canada agreement. Well, they've softened the investment dispute provisions, but in one case, a New Jersey company was denied a permit for developing a series of basalt quarries on the Digby Neck in remote Nova Scotia. And when the environmental impacts it was clear that they were just not acceptable, including impacts on the local communities, the governments of Nova Scotia and Canada denied the permit for the project. But under NAFTA, the company was allowed to sue with a set of private arbitrators, private lawyers, not public agencies. They decided in favor of the company on liability. So that means that Canadian taxpayers now had to pay a good chunk of money. And you can just imagine what that does to the willingness of countries to regulate their environment. Clearly a chilling effect. Another thing to notice here is that we're often talking about non-renewable resources and extractivism. So the added point here is that while you have many of the typical problems of remote ownership and remote investment, you also, with the case of extractivist activities and non-renewable resources, have a problem with the non-cyclical nature of those systems. The quality of ores around the world of various metals like gold is continually going down, and it's never going to go back up. So the circular economy idea doesn't work. That would just turn waste back into raw materials and so on. And the other thing to point out here, it just makes some of the problems with remote ownership even more stark, such as the fact that a lot of mining is driven by market prices with very little consideration of the impacts on local land and people. I'll just refer you to Fred Pierce's wonderful and hard to read book, The Land Grabbers, which really shows how this is happening all over the world. So what is the solution? Well, here's another quote from the Oslo Manifesto about the promise of ecological law. So the ecological approach to law is based on ecocentrism, holism, and intragenerational and interspecies justice. From this perspective, or worldview, the law will recognize ecological interdependencies and no longer favor humans over nature and individual rights over collective responsibilities. Essentially, ecological law internalizes the natural living conditions of human existence and makes them the basis of all law, including constitutions, human rights, property rights, corporate rights, and state sovereignty. So again, that's very loaded. Let's take a little closer look at what some of this means. Here's one way in which I've tries to juxtapose features of our current system, aspects of the problem that ecological law is trying to address in a growth-insistent economy that law supports today, in a regenerative economic system that ecological law would align with better. So shifting from anthropocentric to ecocentric, from colonialism and remote owners to localism and attachment to place, from efficiency to sufficiency, from toxic masculinity to ecofeminism, from the rational man of the economics that arose in the Enlightenment to a plurality of perspectives and views of what the world is and what our relationship with it should be, but from a place-based perspective. From various monocultures, especially money, in terms of how we value things. So our current system is very driven towards using monetary money as a single criteria for assessing value, whereas in ecological law, there would be much more use of multi-criteria evaluation. Instead of commodification, we would move towards respect and reciprocity. Instead of a focus on individuals and private interests, we would focus more on communities and the common good. More broadly, about monocultures, which tend to create systems that are fragile, we would focus on diversity and ecological integrity, which gives systems generally much more resilience against change. And then a move from selfishness, which we've almost fetishized into a desirable thing in our current economic system, to a focus on sharing and solidarity. One really brilliant framing of this is Kate Raworth's work on donut economics, in which she has put forward the idea of safe and just space for humanity. So you have the planetary boundaries on the outside, but then on the inside, concerns about the social foundation that we also have to maintain for people within a system of ecological law. And you may have heard that she's now working with the city of Amsterdam to apply this concept at a local level. That's a very exciting development for those of us working on ecological law. Here's some other notions aligned with ecological law. So ecological integrity, rights of nature or Mother Earth rights, earth jurisprudence, earth law, ecofeminism, ecological legal theory, and so on. I want to just talk a little about one of those, which is rights of nature. Now, rights of nature are perhaps the area associated with ecological law that it's having the most concrete success in terms of reform of legal systems today. So you've had recognition of rights for the Wanganui River in New Zealand and rivers in Colombia and in India and other places. There are regular efforts in the United States, starting with communities in Pennsylvania through the efforts of the Community Environmental CLDF, for I hope folks know who I'm talking about here. That to give rights of nature to at the local level. Those have had mixed success, but they're gaining some currency, and they raise very important issues that are being taken seriously. So in my own work, I've commended these as creating a new mechanism for acknowledging and acting on the fact that our current legal systems and environmental law don't go far enough. But a bit of an asterisk, and that there are elements of any rights-based systems that are still have a leg fairly firmly grounded in anthropocentrism. So, in this doctored up version of Hicks's painting "The Peaceable Kingdom," I've tried to show that you end up having all these rights potentially competing with each other and developing now in an overall paradigm and narrative that I would argue puts them at strong risk. So, in my view of ecological law, we have to encourage rights of nature, but as a transitional step for something that would be more ecocentric in the long run. Whoops. So, and some thought experience experiments that I've come up with, these are questions that you can dwell on for quite a long time, and I'm trying to really try to call out some of these concerns. So first, what if instead of only thinking about ecosystem service to humans, we also insisted that at the same time we also have to think about human services to ecosystems? This is an example of what we mean by reciprocity, or considering obligations and responsibilities along with rights. Another question, what if instead of focusing on rights of nature as giving personhood to nature in law, we work towards ecological law that gives naturehood to people in law? And I've written recently on this, and what I realize is that naturehood is not a concept that we're familiar with even outside of law, let alone within law. And for me, that exemplifies, in some sense, how it's an idea worth developing, but also how challenging it will be to create a framework of, especially a legal framework in which that makes sense. But I've just written a book chapter, and I hope others will help think through that particular thought experiment. Some of the answers I have found come from lessons we can learn from ecological or ecocultural restoration. So these are processes of assisting the recovery of an ecosystem or an ecocultural system that has been degraded, damaged, or destroyed. And some, I think, relevant features of this are, first of all, that these restoration efforts are always intentional. They're always involve goal-oriented intervention. So this points away from some of the laissez-faire aspects of how we deal with environmental problems in the larger context. We really need to be very intentional about where we're going here. And what's done here is there's reference to historical conditions in which a mutually enhancing human-earth relationship or something like it existed. Maybe you frame that in terms of ecological or ecocultural integrity. But you have some sense of conditions that you want to work towards that existed in that place at some other time. It always involves recognizing embedded, resilient, and communal connections of people and place, and this implies then that it has a strong focus on locally tailored options. So for ecological law, one of the questions we can ask and do some serious thinking about is how can we apply this approach beyond site-specific small-scale restoration efforts to multi-scale restoration up to the global level. And related to this are lessons we can learn from the work of Eleanor Ostrom, from Agrawal and others who have done research on common pool resources and ways that local communities have found to use them sustainably for long periods of time. And these are the criteria that Ostrom found were necessary when in any system that has a sustainable use of common pool resources. This, by the way, I think is very relevant, first, not only to emphasizing the need for locally tailored place-based solutions as part of ecological law, but also that ecological law necessarily then involves a diverse and plural view of the kinds of arrangements that can be come up with. In other words, the answers that ecological law provides are not necessarily, and probably are rarely, tied predominantly to the state level, to the nation state, or even subnational jurisdictions where they're not consistent with this emphasis on attachment to place. So together, again, these lessons: key role for human choice, intention, and goal-oriented intervention; strong need for monitoring and adaptation to see whether the goals that you're trying to work towards are being achieved, and if not, making adjustments; and then a flexible range of options. There's no one possible reference to historical conditions with mutually enhancing human-earth relationship, but that gives a broad and very strong foundational idea on which to base goals. And again, this focus on locally tailored options and enhancing attachment to place. The last thing that's true in all of these successful endeavors in Ostrom's example and in eco-cultural restoration is that they involve participatory dialogue and decision making. This cannot be a top-down approach. In fact, in Ostrom's example, one of the criteria is that local communities have been given the leeway to develop their local arrangements by levels of government that are above them, and if they wanted, could step in and insist on something different. So also reflected in here is this notion of subsidiarity, which I boil down to as being the rule that global rules should be for global matters, like respecting ecological limits, while maintaining local control, culture, and traditions. So let me now close up with some thoughts on transition. First of all, what we're looking at here is a constantly moving target. If you take a systems-based perspective, you look at the world, you look at where we've been, and because of path dependence, that means that certain things are no longer possible. So we have to focus on possible futures. And then we can break that down into which of those futures are consistent with a growth-insistent paradigm and approach, which are consistent with a mutual human-earth enhancement. And where is that transition? Because that's where we have to start. But the other point here is that this is a situation that constantly changes with time. What's possible today may no longer be possible tomorrow. So that underlies some of the need for urgency here. Obviously, this is an enormous challenge. We have to untangle and reorient a massive network of interconnected systems that are hardwired against change in many ways. And again, ecological law requires not only radical transformation of environmental law, but also of the entire legal system and of all those systems that are intricately connected to it. So I turn here again to maybe scaling up ideas from ecological and eco-cultural restoration as a good starting point. So there's many things going on with the folks I'm involved with in trying to develop what ecological law is. One of the most recent things we're doing are called ecological law case studies. These are real-world situations, say a project, a development project, a mining project, a policy, a sectoral feature. And the idea is to deconstruct that situation, to identify and analyze all legal and policy features of the situation that are both direct and indirect. The idea here is to do a lot of brainstorming to really look at not just environmental law, but all of the legal features that touch that situation and at all governance levels. Then to analyze it, for example, using Carlos Spert's lens of ecological law, to say, well, what parts of this picture are consistent with our understanding of ecological law and where we want to go, and what things aren't. And then reconstructing that situation, describing the legal and policy features that would apply in a regime of ecological law, again, at all levels. The reason to do these is to show concretely how ecological law transforms all law, not just environmental law, to make clear the inadequacy of the status quo and how hard, in some cases, the obstacles are to overcome, to highlight transitional forms in the direction of ecological law, and to illustrate a clear vision of ecological law on the ground concretely and not just in theory and concept. Here's just another presentation, a schematic of what this would look like, deconstruction, analysis, and then really two phases of reconstruction probably make sense. One, transitional, where what you're aiming for seems a little realistic given where we are today, and maybe a final result that you would want to achieve in the very long term. As an illustration, I'm considering doing one of these for an area outside of Montreal called Quartier 1030. It's described on there as Canada's first lifestyle center. Well, there's some pictures, and this is what it's all about. So a commercial lifestyle center located in Brossard, Quebec. It was designed to emulate an urban or downtown shopping experience with boutiques and to meet the needs of suburban dwellers living on the South Shore of Montreal. So, lifestyle center. this is a kind of a fairly quick thought experiment with respect to this, but what is the worldview? What is the understanding of the human-Earth relationship and the vision of the future that this project reflects? And what then are the alternatives with ecological law? How would we break down the consideration of true need versus utilitarian desires? How does this link up with regimes of trade in Canada and Quebec and with local regional law and policy? What does it say about appropriate land use, keeping in mind that this project involves conversion of very good farmland for suburban development, and that it's situated at the intersection of two autoroutes? What does it say about lifestyle, and how does it deal with concepts reflected in the planetary boundaries? So our idea here is to do a number of these in Eastern Canada and in Northeast United States. I'm working with teams in Quebec, Vermont, including Vermont Law School, with my wonderful colleagues Hilary Hoffman and Kimben Roth, and in Brazil, and with a group at the Universidade Federal de Santa Catarina, and potentially in Africa and Nigeria. Kimben Roth, I'm sorry, Kimben, I flipped up there a little bit. The idea is to look at each of those case studies and do a comparative analysis with a possible book. So that's just one effort underway. We have others going on in the Ecological Law and Governance Association, and here's the website if you want to check that out a little bit more. The Oslo Manifesto is on that website, and gives a good 2-page summary of some of the things I've talked about today. Within the Economics for the Anthropocene and Leadership for the Ecozoic Law and Governance Research Project that I coordinate, we held a workshop in October that led to a special issue of the Vermont Law Review in the spring of 2019. And we have a regular series of webinars that are posted on the ALGA website, and I invite you to join those. Rights of nature is a very active part of this field of law. Ecological law case studies is this new effort to try to give a more concrete understanding of what ecological law means. I see the degrowth movement as a natural partner or area in which to develop the laws related to ideas related to ecological law. Some leading books on this topic: Klaus Bosselman and his partner Prue Taylor wrote a book in 2017 called Ecological Approaches to Environmental Law. And this is really setting the stage for where we are now. David Boyd's recent book, The Rights of Nature, is also very relevant. And again, Carlos Bert's book, The Lens of Ecological Law. Coming up is a book that I'm co-editing with Kirsten Anker and others called From Ecological to Environmental Law, with 16 authors, several of them from Vermont Law School, which is just wonderful. Hilary Hoffman, Kimben Roth, and Reed Loader. And then my own book, which is coming out in October, Ecological Law and the Planetary Crisis. So I want to end there. Thank you very much for your attention. I know that I covered a lot of material and maybe some of it a bit superficially, but as I said, even for me, this is still raising as many questions as it's providing answers. So I look forward to having some from you now. Thank you.
Great. Thank you so much, Dr. Garver. We have a few minutes to ask some questions from our audience. As a reminder, for those of you who are watching on our website live stream, you can click on the watch on live stream icon at the bottom of the video to bring up the chat box where you can add your question. Or if you're watching on our Facebook live stream, add your question to the comment box below, and we'll try to get through as many as we can. First question: what opportunities or challenges does COVID-19 provide to catalyze a shift away from the dominant market-centric narrative?
Well, that's a very good and very timely question, and certainly one that people in the world of ecological law are thinking about. We on the steering committee of ELGA are working on a statement that we hope to put up on our website soon. I think one of the major needs or lessons that I would emphasize is that we've seen a lot in this crisis about what's essential services. And I think maybe even ordinary people around the world have discovered a little more of what they can do without and what really they thought they needed but don't need, and maybe even was causing problems in their life. So I mentioned this feature of ecological law is focusing on true need as opposed to things that we might have to start seeing as luxuries given the challenges with planetary boundaries and so on. So that's, I think, a really strong lesson. I think there's also other lessons from successful ways in which this crisis is being and has been dealt with about solidarity among people, community building, in a sense that we're all part of something together, that there are things that affect us across the globe. That means that we're interconnected in a lot of ways. And lessons we're learning about what happens when we encroach too far on the ecosystems that support us, because there's a lot of evidence that that's the source of this unprecedented virus.
Great, thank you. The next question pertains to the Supreme Court of Canada's future ruling on the Greenhouse Gas Pollution Pricing Act. Do you think the Supreme Court will recognize the phenomenon of ecological law? What are the dangers of furthering the principle of the protection of corporations in this decision? How would vulnerable communities, such as Indigenous communities, be impacted if the courts continue to omit a lens that encompasses an ecological approach to law? And what can we do to disengage in airbrushing history? All one question.
Okay, let me whoosh. Let me try and at least get to some of that. So, I assume so. The Supreme Court of Canada will be weighing in on the government of Canada's carbon pricing scheme. This some efforts that are being developed and with respect to climate change, I think are best seen as transitional rather than as true examples of ecological law. So there's some. Certainly we need to get more serious about climate change. But even choosing pricing over, say, a cap and trade system already makes a choice that, to me, creates a problem with ecological law. Because if you have a cap and trade system, your focus is on the cap, and that can be much more science-based. You're focusing on the amount that we can afford to emit without crossing critical boundaries. If you choose a pricing plan, you're automatically commodifying the pollution. You're trying to put you are forcing the exercise of what money has to be spent in what kind of ways to contain the problem, and that is perennially difficult, if not impossible, to do. It's a constant guessing game. So you set a tax, and then you're going to have to reset it, and so on and so on. I think it's likely that the Supreme Court is going to find that the pricing system was okay. Corporations. If you look back when I talked about the growth consistent paradigm, there are really some extreme examples that we have to reckon with, and some of them are happening in Canada, in Alberta, and other places. Quebec, where I live, I think is strongly considering the need to perhaps put environmental regulations aside, either because of the COVID crisis or in any event. This idea that we've gone too far environmental protection is really for the true believers of that growth-oriented paradigm, but it makes absolutely no sense if you take a systems-based approach to the human relationship and how we have to improve it. I don't think I got to all aspects of that question, but I hope that's at least a start. I would love to see, by the way, love to see an analysis of whatever the Supreme Court of Canada does with some of the features that I talked about of ecological law. That would be a really useful contribution to this evolving and emerging field.
Great. So another kind of package of questions, and I'll give them to you at once, and you can decide how much and which to answer. This relates to oceans. Could you expand on ocean acidification as a safe zone if marine species are disappearing from traditional habitat 2 times faster than their land counterparts? And then following up on that, in that regard of ocean ecological shifts, can you also expand on use of the precautionary principle regarding management of shifting marine species and suitable habitats? And specifically, that person's thinking of replication agreements like among the Arctic nations to ban fishing in the Arctic Ocean until more is known about ice loss on local fisheries.
Well, to be clear on the ocean acidification boundary, the idea of the boundary is that it would need to be set at whatever threshold would be determined that would prevent some of the irreversible changes that are of concern. So I think there's a serious discussion, a lot of thinking to be done on what precautionary means, but a safe zone does not, is just by definition something where certain things can't happen. One thing about the article that I cited, the Stefan et al. From 2015, is that it sets out biodiversity and climate change as kind of overarching boundaries, and that makes a lot of sense, especially with climate change. So ocean acidification is related very strongly to climate change. So the things that you would do to address ocean acidification in many ways are ones you would do to address climate change. Shifting habitats, whether it's in marine or terrestrial ecosystems, is a really big problem. And we have to be thinking about both what we can do to mitigate that threat and also to adapt to it. And we're going to have to be dealing with inevitably at this point with some loss of some habitat, along with doing whatever we can to protect habitats. Shifts in habitats at the top of mountain ranges or at the northern parts in the northern hemisphere of ranges of species, those are changing almost faster than we can do anything about it. So those are big problems, and thank you for asking them to illustrate sort of the depth of the issues that we're dealing with here.
We have an unprecedented number of questions, I have to say. This has been a really thought-provoking topic, but we have to wrap up because our students, many of them have class at 1 o'clock, so we need to give them a moment to transition over. So thank you so much, Dr. Garver, for such an interesting talk. To our listeners, next week, Vermont Law School will be closed for summer break, and so we'll have a short break from the lecture series. Our next talk will take place on July 7th, and we hope you can join us then. Thank you, Dr. Garver, and thanks to all our listeners.
Thanks, Jenny. And anyone who's listening, if you happen to write down my email, feel free to contact me. I do welcome the exchange. Thank you so much. This was wonderful.